Hey everyone, today I'm going to talk about Canadian law and self-defense. What you can do and what you can't do. Stick around to find out more. So, first things first, let me start off by saying I am not a lawyer, nor do I play one on TV. Although I am open to it if any casting agents are watching this video. The information in this video comes from talking to police officers and lawyers. I actually wanted to bring on a lawyer for this episode. He declined, however, citing that every case will be slightly different, and he did not want to give advice on a case that is not specific. For example, can you do whatever is necessary to keep yourself safe? Like breaking someone's arm if they throw a punch at you? Well, it depends. Was it this guy? Or was it this guy? You can see that there is an obvious difference in the two scenarios. Is it really necessary to break their arm to keep yourself safe? In the first case, it might be. In the second case, probably not. The big takeaway from my discussion with this criminal defense lawyer was that it has to make sense. So in a year's time from now, looking back objectively, did your actions make sense? If this guy punched you, you may very well have believed that breaking his arm was necessary to stop the attack. If this guy punched you, you'd have a hard time getting someone to agree that it was necessary for your safety. Self-defense is the act of protecting oneself against a real or perceived threat. This usually involves the defender using physical force to detain or stop the attacker from harming them. There are many events that might cause someone to defend themselves, each with their own unique circumstances. These include attempted assault, attempted rape or sexual abuse, robbery, kidnapping or abduction, trespassing, or extremely threatening behavior. Though the right to defend oneself can appear straightforward at first, it must be examined on a case-by-case basis. Every year, a number of Canadians are charged with criminal offences such as assault or even manslaughter, even though they might believe they were trying to defend themselves. This is due to not fully understanding the limits of the right to self-defense and gravely harming their attacker. Unfortunately, there are many misconceptions about self-defense which can land someone in difficult legal territory. So, what are you legally allowed to do to defend yourself if you are attacked or reasonably believe that you will be attacked? Essentially, you are allowed to do what is reasonably necessary to keep yourself safe. Note the use of the word reasonably. As in the previous example, you may in some cases be justified in breaking someone's arm if you feel it is necessary to keep yourself safe. Staying around afterwards to continue to lay the boots to them, however, would make you the assailant. Again, your actions have to make sense. Do what is necessary to keep yourself safe and then get away. Does weight, size, gender, martial arts training matter when it comes to what you are able to do to defend yourself? To answer these questions, we have to go back and examine, does it make sense? A 200-pound male experienced martial artist fighting off a 140-pound female with no martial arts background becomes very different if she's attacking with a knife than when she simply comes swinging her fists at him. In both cases, he would be justified in defending himself. However, the use of force required to do so would vary greatly. Can you still claim self-defense if you start the fight? It is possible to claim self-defense if you are the one starting the fight. However, in order to do so, you must truly believe that your well-being is in danger. If you reasonably believe that you needed to take a proactive approach to keep yourself safe, you might be able to claim that it was in self-defense. For example, you've allowed someone to back you into a corner and you feel that your only way out is to hit your assailant to create space and get away. You would have a hard time justifying this, however, if you had the space and opportunity to walk away from the situation and didn't use it. Can two people legally agree to fight? In Canada, you can consent to a street fight with another individual, but it gets complicated. You can agree to a street fight, but you can be charged with disturbing the peace. According to the Canadian Criminal Code, Section 175, everyone who by fighting, screaming, shouting, swearing, singing, or using insulting or obscene language is guilty of an offense punishable on summary conviction. So while you are legally able to consensually fight another person, you could still be charged with disturbing the peace. Aside from that, you can consent to a street fight, but you cannot consent to causing bodily harm. Canadian law provides that a consensual fight is not an assault because both parties have agreed that there will be some physical contact. This consent, however, does not extend to causing bodily harm. The Supreme Court of Canada ruling in the case of the Crown versus Jules Jobidon offers an example of this. The accused had been arguing with another man in a bar in Ontario. The accused was challenged by the other man to fight in the bar, but it was broken up. They both agreed to continue the fight outside. After waiting outside in the parking lot, the accused punched the other man in the head, knocking him backwards onto the hood of a car. The accused carried on and in a brief flurry struck the victim repeatedly in the head, even after realizing that the victim was unconscious. The victim rolled off the hood and lay limp. He was taken to the hospital where he later died. Jobidon was charged with manslaughter, and at the original trial, he was found not guilty. The trial judge held that the victim's consent to a fair fight negated an assault. The trial judge's decision was overturned by the Court of Appeal, which instead found the accused guilty of manslaughter. The Court of Appeal decision was then appealed at the Supreme Court, which was tasked with deciding whether the absence of consent is an element that must be proven by the Crown in assault cases or whether limitations could be placed on consent in certain circumstances. The Supreme Court ruled there are limitations on the extent of harmful conduct to which one may validly consent and thereby bar conviction for assault. The appeal was dismissed and the manslaughter charge was upheld. The judges found the accused, by continuing to pummel the victim after he knew the victim was unconscious, knowingly acted beyond the ambit of the victim's consent. This ruling established that consent could not be used as a defense for causing serious or non-trivial bodily harm. So while you can consent to a fist fight, once a person has lost the fight or the fight continues beyond the point of non-trivial physical contact, it is pursuant on the winner to stop the fight. If a person has been knocked out or in any way decides to stop the fight, any further violence is considered a crime. What if somebody breaks into your house and you shoot them? That's okay, right? Once again, we need to go back to, does it make sense? Two men break into your house and are making their way upstairs. You own a gun, which you use for hunting. You get it out and shoot them. You may be okay in this situation. A man breaks into your garage and you pull out the unregistered gun you keep and charge into the garage looking for him. You'll have a much harder time selling this as self-defense, as well as having to answer for owning an unregistered gun. What weapons are legal for self-defense in Canada? In Canada, you are not allowed to carry any weapons for the purpose of self-defense. Self-defense laws in Canada are about purpose and intent. If you were carrying a weapon for self-defense, in the eyes of the law, you intended to use the weapon before you were even attacked. You can check out my video here for more details on this. While you are not allowed to carry a weapon for self-defense, there may be some circumstances where you could use one if you were being attacked. This is where purpose and intent come in. The reason for you having the weapon readily available is what's important here. For example, you're coming back from baseball practice and have your bat in the car is much different than carrying a bat in the car in case you need it for self-defense. Picking up a stick off the ground and hitting someone with it would be different than carrying a stick for that express purpose. Spraying someone with bear spray that attacked you while you were camping may be feasible, while spraying someone walking home at night would not be. Once again, it is the intent and purpose that is important in all of these examples. Also, the weapon must only be used to defend oneself against very severe and probable threats. What if somebody attacks me and it comes down to my word versus theirs about what really happened? They say I attacked them when really it was the other way around. If it comes down to your word versus your attackers, the biggest thing that will be looked at is your credibility and reliability. If you work full-time, don't have a criminal record, and have never been in trouble with the law, you are more likely to get the benefit of the doubt over someone with a history of law infractions. What should I do if I've been attacked and I've injured my assailant defending myself? In this situation, you should contact a lawyer immediately. Tell them everything that transpired so that there's a record of it and it doesn't look like you're trying to hide anything. Conviction in an assault case could lead to a lengthy jail sentence, so you'll definitely want to have professionals defending your case that know what they're doing. So there you have it, what you should know about Canadian self-defense laws. If you enjoyed the video, please smash that subscribe button below, like, share, and leave a comment. I'll see you all in the next video.